video, we're going to be talking about the next section of the rules, specifically transactions and communications with persons other than clients. And to get started, remember that this section of the rules makes up 2 to 8% of your total MPRE examination. So the first rule that I would like to direct your attention to is our truthfulness in statements to others. It's a fairly loaded rule, so we're going to look at the language of it, and then we're going to break it down and even talk about some examples. So the rule tells us that in the course of representing a client, a lawyer shall not knowingly, 1, make a false statement of material fact or law to a third person. So to stop there, this means that while you're representing a client, you as a lawyer shall not lie, whether it's about a fact of your case or about the law, for instance. You shall not be lying to anyone. The next part of the rule says, in the course of representing a client, a lawyer shall not knowingly fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by the rules of confidentiality. So I have a lot to say about this prong of the rules. First things first, essentially this rule is generally saying you cannot lie by omission. Failing to say something, if that failure to speak up amounts to a lie or misrepresentation, that's very problematic under this rule. So not only is this rule trying to encompass what you do say, but it's also trying to encompass failing to act or failing to speak up when you should be speaking up. So if you lie by omission, you're still lying, and therefore it's going to be problematic under this rule. Something else I want to point out, what this is saying is you shouldn't allow your client to use you to commit a crime or a fraud. So for instance, if you know that your client is failing to disclose something and that failure to disclose something amounts to a crime or fraud, you got to step in and you have to speak up, because failing to do so would again be lying by omission and therefore be a violation of this rule. So the other thing I want to point out is this prong of the rule essentially points us back to our duty of confidentiality that we learned about previously in the course. So what this is specifically saying is that if there's an exception to our duty of confidentiality, which remember there are 6, it basically says that if there is an applicable exception that allows you to disclose a client confidence in an effort to avoid assisting your client in some sort of criminal or fraudulent action, then you must. In other words, it turns the mays under our exceptions to the duty of confidentiality into a must. So let's look at our example in the outline. It says a lawyer is assisting a client in the sale of a building. The building has asbestos, and both the lawyer and the client know about this fact. Failure to disclose known asbestos is a crime in the jurisdiction. The lawyer does not correct the client's disclosure document stating that there is no asbestos in the building. Lawyer would be subject to discipline for this. And this is because there is an exception to the duty of confidentiality that would allow the lawyer to make a disclosure in this instance, and therefore the lawyer has to make a disclosure in this instance, or they have violated the rule. So moving on, the rule goes on to tell us that misrepresentations can occur if the lawyer incorporates or affirms a statement of another person that they know to be false. So for example, going back up to that asbestos example, if the lawyer signed off on this paperwork that the client made these disclosures on, guess what? The lawyer just affirmed that and therefore is liable for that. But the other thing to keep in mind is that this rule is trying to be fair. The rule is trying to strike a balance between those instances in which a lawyer knowingly lies or lies by omission or misrepresents information, and those situations where a lawyer is advocating on behalf of a client, maybe trying to settle a claim and engaging in negotiations. So we're trying to strike that balance to realize that not every single thing a lawyer says amounts to a statement of material fact. So the rule tells us that under our generally accepted conventions of negotiation, certain types of statements are not taken as statements of material fact, such as estimates of price or value placed on the subject matter of a transaction. So for instance, if you say something like, I'm estimating how much my client's claim is worth, or I'm estimating the value of something that you're representing on behalf of a client, You can do that when you're negotiating, because the goal of negotiating is to get your client the best deal possible. Or a party's intentions as to an acceptable settlement of a claim, or the existence of an undisclosed principal, except where non-disclosure constitutes fraud. So again, these are all things that we do not by definition consider to be material statements of fact. So therefore, if you are engaging in negotiations, you're not automatically violating this rule, for instance. The next rule that I want to talk about is the next one up, communication with represented persons. So again, this is a pretty loaded rule. So let's take it piece by piece. The first part says that in representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has consent of the other lawyer or is authorized by law or court order. If the lawyer learns that a person to whom he is speaking is represented by a lawyer, the lawyer must immediately terminate communication with that person. So stopping there, again, this is pretty loaded, but at a basic level, this is saying that if you're representing a client who is suing someone, and let's say that opposing party is represented by a lawyer, you should just be communicating with that other party's lawyer. And in fact, that's likely to make your job easier, just to communicate with the lawyer rather than the party directly. Now, if you talk to someone and you don't know they're represented and you come to know they are, you immediately need to terminate that conversation. That's why it's very wise for a lawyer to maybe open up conversations with someone by asking if they're represented. This way the lawyer knows whether or not they can move forward with that conversation or if they should be cutting it short. The other thing I want to point out is that if the law or court order is allowing you to speak to someone who has representation, then you can. That's essentially like an exception to this rule. But generally, you should just be talking to that represented person's lawyer in the matter. So a few things to keep in mind. The rule applies even though the represented person initiates or consents to the communication. So if you have a situation where you're representing a client and the opposing party has a lawyer, but the opposing party insists on consistently calling your office and trying to speak with you, what you should do is have your support staff tell them that they need to stop calling your office. And then what you should do is call that person's lawyer and say, hey, your client keeps calling us. So either give us permission to speak with them directly or have your client stop calling our office. So it doesn't matter that the represented person wants to talk to you. If they have a lawyer, you need to be going through that lawyer. Next, this only applies to the matter of the representation. It does not prohibit communication with a represented person or an employee or agent of such a person concerning matters outside the scope of the representation. So let's say, for instance, you're representing Bob in a car accident case, and Bob is suing Alan, who's represented by a lawyer, and you notice up at deposition, and you show up to the deposition, and Alan is trailing right behind you. So if you want, you can hold open the door for Alan as you enter the building, and you can say, nice day, huh? Or isn't the weather beautiful? Why? Because that has nothing to do with that car accident case, and you're allowed to have that type of communication with someone who is represented. The prohibition on communication with someone represented is as to the scope of the representation, because again, they're represented, so you should only be speaking to their representation about the matter. Now, we're not quite done with this rule yet. The next part of this rule discusses organizations, and a lot of people tell me they struggle with this rule. So hopefully we can pull it apart and make it a little bit more manageable for you to understand. So as this applies to organizations, if it's helpful for you to think of organizations as like a corporation, then do so. This rule is broader than just corporations, hence it uses the word organizations, but sometimes it's easier to get a better feel for this rule first, maybe thinking of it as a corporation. So the reason this rule I think is tricky is, for most people, is because when you're dealing with like a basic lawsuit where A sues B, we know who the parties are, A or B. But when it comes to entities or organizations suing each other, an organization like a corporation, for instance, is not a person, but instead they're ran by people. So it becomes a lot more challenging to say, wait, who can't I talk to if you're the lawyer representing someone in that matter? And that's what this rule speaks to. So the rule says, in the case of a represented organization, the rule prohibits communications with a constituent of the organization who supervises, directs, or regularly consults with the organization's lawyer concerning the matter. So let's stop there. Let's say you are an employee of a big corporation and you're fired and you believe it's wrongful termination and specifically maybe in breach of an employment contract you had. So you hire me to sue your ex-employer, this big corporation. So as it relates to this rule, the corporation is the opposing party. The corporation has counsel, let's say. So if there is the CEO, for instance, of this business who is in regular contact with the corporation's lawyer, then I shouldn't be talking to the CEO as it relates to your representation. What this rule is saying, I should kind of like treat that CEO almost as like the client, and I should just be going to their lawyer directly. The next part of the rule says, in the case of represented organizations, this rule prohibits communication with someone who has the authority to obligate the organization with respect to the matter. So for instance, if the board of directors, in my example, has the ability to settle this case that you bring against them, I shouldn't be speaking to the board of directors directly. I should be speaking to the lawyer that's representing the company. Or anyone whose actions or omissions in connection with the matter may be imputed to the organization for purposes of civil or criminal liability. So anyone who can do something and get that business in trouble is the type of person that I shouldn't be speaking to. I should just be speaking to the lawyer on behalf of that organization. Now, I want to point out the note, consent of the organization's lawyer is not required for communication with a former constituent, but be careful here. So let's give you a quick example. Let's say a corporation has a CEO that quits. And going back to the example I previously gave you, let's say I'm representing you in the lawsuit against your ex-employer, this big corporation, and their CEO quits amidst our representation. I'm allowed to talk to that former CEO of the company because they're no longer part of that company. But I need to be very careful. I'm not allowed to ask them to break any sort of confidentiality or attorney-client confidences that maybe they've had with the organization's lawyer. So am I allowed to speak to that former constituent? Yes. Am I allowed to violate the rules otherwise? No. So I can't ask them, for instance, tell me what you talked about with the corporation's lawyer. No, because I'm asking them specifically to violate attorney-client privilege, for instance, and I'm not allowed to do that. Finally, the rule says that these rules don't apply to represented persons communicating with one another. So just to be clear, if I'm representing Bob and you're representing Alan, I'm not supposed to talk to Alan directly because he's got you as his lawyer, but Bob and Alan can talk to each other. That is totally fine. The rules allow for that type of communication. So I briefly want to point you in the back into the outline to talk about the example there. It says a husband and a wife were each represented by their own attorney in a bitter divorce action. While it's improper for the husband's attorney to talk to the wife without counsel or vice versa, the husband and the wife are permitted to discuss the matter amongst themselves. So again, the clients represented as parties in an action can speak to one another directly. The other thing I want to point out is that your client can ask you for guidance about the ability to talk to another represented party. So for instance, if I'm representing the husband in this matter and you're representing the wife, if the husband, my client, wants to come to me for advice about how to communicate with his soon-to-be ex-wife, he can do that. I'm allowed to give him that type of advice because, again, the parties are allowed to be communicating with one another. The final rule that I want to talk about is about communications with unrepresented persons. So we're kind of talking about the flip of the rules we've just previously been discussing. So the rule starts by saying, in dealing on behalf of a client with a person who's not represented by counsel, a lawyer shall not state or imply that he is disinterested. So we all know that if you're representing someone in a matter and they maybe are suing someone who doesn't have a lawyer, it's impossible to move that action forward without speaking to the unrepresented party. You have to be able to communicate with them. And the rule recognizes this. However, you have to be careful in speaking to them. You can't act disinterested. So for purposes of the MPRE, please read quoted language carefully. If they do provide you language in quotes, circle back to it and double check it. Because the idea is if you are hired by someone and they are your client, you aren't disinterested, you're very interested, right? You're supposed to have their best interests in mind. So you have to be very careful with how you speak to someone who is unrepresented. Now, when the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct that misunderstanding. So if an unrepresented person keeps coming to you and it's very clear they're confused about your role, maybe they're asking you for advice, you need to take steps to keep reminding them that you are not their lawyer and you do not have their best interests in mind. And then lastly, the lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel if the lawyer knows or reasonably should know that the interests of such a person are or have a reasonable possibility of being in conflict with the interests of a client. That's a very loaded portion of this rule, so let's break it down. What it's saying, which I think a lot of people don't understand, is you don't have to tell someone to get a lawyer. Some people think the very first thing you must say to someone unrepresented is that they should get a lawyer. And that is not the case. That's not what this rule is specifically saying. What this rule is saying, if you're representing a client and there's maybe an unrepresented person you're dealing with that has a conflict of interest or a potential conflict of interest with your client, you should not be giving them legal advice because by doing so would create a conflict of interest. So if a situation arises or maybe they come to you and it's a situation where you might have given them legal advice if you weren't interested in the matter, the only type of legal advice you should give them is to go get a lawyer. The other thing I'd like to point out about this rule is it's generally saying we shouldn't be going around giving legal advice to people who aren't our clients, right? Generally, we should be representing our clients and taking care to not create a conflict of interest. So if there is someone not represented coming to you or seeking help, you need to clarify your position, and the only advice you should be giving them is for themselves to go get a lawyer. So that wraps up this section of the rules.